appeal in the matter of Busting Ltd and Shenzhen SKE Technologies Co Limited and others.
Yes, Mr. Eden.
My lord, my lady, I appear with my learned junior, Mr. St. Quinton, for bargain busting, which is the claimant but also the appellant in this matter. And my learned friend, Jonathan Moss, one of His Majesty's Counsel, Laura, Addy and Joseph Kay appear for SKE, who are the first defendant and they're the respondent in this matter. I presume that you've all safely received the relevant bundles, so there should be a core bundle, a supplementary bundle, and 3 authorities bundles.
Yep.
Good. Pursuant to the notice of Lady Justice, Chief Justice Baroness Carr of the 8th of November 2023, mindful of the fact that my learned junior is here, we weren't going to proffer him a speaking slot for 2 reasons.
You don't need to justify it. It's perfectly understandable.
He's also been before you, my lord, twice in the last 3 weeks or something.
Indeed.
He's probably had enough. probably appeared before you sufficiently for you to form an opinion. Sorry, my lord, that came out with the pause in the wrong place. Moving on, he says. The matter is being live transcribed. If I may ask for a short break at half-time.
We don't usually take a break in this court, I'm afraid.
Fine.
And we appreciate the labours of the transcribers, but there it is.
My lord, I've asked, and so that's the matter. Then, moving straight on, this is an appeal from a judgment of Mr. Justice Miles, as he then was, 21st of May 2025, and his order of the 27th of May 2025.
Yeah, and that prompts me to ask a few questions about chronology. And I'm grateful to the parties for the updated chronology, but there are still certain question marks which remain, some of which are unimportant, but nevertheless, I just want to get a picture. So the first, if we look at the judgment, a cover page, this is page 87 in the bundle. First of all, one can see the legend, further documents, 6th of May. I take it that means written submissions. Is that understanding correct?
I'm sorry, my lord, 87 is the beginning. So...
Yes, it's the cover sheet.
Oh, sorry, you're right.
Further documents, 6th of May. I'm assuming that that's a reference to written submissions.
No, there weren't any further.
All right, well, perhaps you can investigate and let us know. Second question, it records that the draft of the judgment was sent to the parties on the 8th of May and yet had not handed down till the 21st of May, which seems odd. Are you aware of any specific reason for that delay?
I can't recall any. I'll have to go through my emails to check why there was a delay.
All right, well, again, if you could look into
I'll
that.
do that.
I mean, if there's no apparent reason, then so be it, but I just wanted to know if there was some particular reason for it, because otherwise it seems unusual and odd. Now, next question is actually more substantive, which is this. Am I right in understanding that as of the date of the hearing for the judge, there was no trial date set?
That must be right, yes.
There is no mention.
Shall I explain partly why that's so?
All right.
You now know that this case has been joined with another case. And so therefore there was a large CMC to basically manage the cases.
Well, we may need to come back to that point in a second, but there is no reference in the judgment to the question of a speedy trial.
Correct.
I am assuming, therefore, that the question of a speedy trial was not debated before the judge.
That is correct as far as I'm aware. I've read the transcripts on both day 1 and day 2 recently, and speedy trial never turned up as far as I can recall.
So the question is, why not?
I have no answer to that. I mean, we were resisting the injunction application. There were clearly a large number of matters between these parties. The most pressing at that time was an appeal from the IPO to the High Court with respect to the crystal bar mark. And the point about that is that if that appeal was unsuccessful, then it was the intention of Bargain Busting to join that mark into the case. And so it would probably be premature to have pressed for a speedy trial, not knowing the final status of a crystal bar mark.
But the High Court decision came not long afterwards.
Yes,
So the hearing date must have been fixed by then.
The hearing date was fixed, but there's 2 points. The first of which was that SKE sought to appeal, a second appeal, from the High Court appeal of Mr. Tappin sitting.
Yes, but that wasn't known at that stage. I mean, it could have been anticipated as a possibility.
It was,
and equally, one could have anticipated what happened, viz. The permission for a second appeal was refused.
yes, it was anticipated that there would be an application by the losing side, and certainly if Mr. Tappin had decided in favour of BB, which is what he did, it was anticipated that any second appeal would be refused, because then that would be in essence 2-0 to Bargain Busting. But the point being is it then took a long time for the decision of Mr. Tappin to be implemented at the IPO.
Well, yeah, I don't want to get into that whole saga.
Fine.
But that wasn't something that was on the agenda.
True.
At the time of the hearing before the judge.
Yes, that is true.
All right. Now, can you then bring us up to speed? Where do we stand now? Do you have a trial date even now?
Yes. March 2027. It's listed for 14 days, 2 days of which are pre-reading, 2 days of which are a break to prepare for final submission, so 10 days in court. It's now been joined with another action, which was an earlier action, which has slightly different issues because there's a registered design aspect with respect to the design of these vapes. And that's where BB is a defendant. But the matter might be complicated by the fact that a related entity to SKE has now sued BB with respect to another crystal mark. That's Crystal Vapors. And even though it hasn't yet been decided, it's CMC, isn't it? It's held last week. Okay. Yeah. So there's been an agreement for some sort of joint management between those original 2 cases and this new 3rd case. But the fruits of that agreement are not yet known, so to speak, how the courts will deal with that. Now that potentially will increase the length of the proposed 14-day trial, because for 2 reasons. One, it's a different mark and therefore slightly different considerations. And the key point there is there's different considerations with respect to the earlier goodwill. And there's not much to argue about the difference between crystal vapors and crystal bar and those alleged conflicts and things like that. But the point is the goodwill that appertains in particular to crystal vapors is going to be an issue of fact. And that might be actually quite complicated. So therefore that could well foreseeably lead to an increase in time estimate.
All right, but this is helpful context for us, and I'm grateful for the explanations. but the additional complexity that's come in subsequently wasn't something that
That's correct.
was known at the time in April, May 2025.
Yes. But to go back to that critical point about why speedy trial wasn't raised, all I can say is the focus at that time was upon the interim injunction application and the appeal from the IPO. So there was not a focus upon bringing the whole dispute rapidly before the court.
All right, that's helpful, thank you. So,
While we're on chronology, could I just ask this? I may have missed something, but the offending letter was sent just before Christmas,
Yes, my lord.
and the hearing took place in April.
Yes.
I've seen no evidence of any undertakings or interim order in the meantime.
Correct.
How was the parties' conduct regulated?
The parties' conduct was not formally regulated by either any interim relief, so to speak, or an undertaking. What the matter was that BB had indicated that it had no intention to write to anybody else, and that was what happened. They didn't write to anybody else,
Right.
save for
So they didn't. It was not thought that there was sufficient doubt on that topic to justify a without notice or short notice application.
true, but
The statement of no intention to repeat was not considered sufficient to defeat the application.
True, but there's two nuances to that. The first of which is that the delay between the issuing of the interim injunction application on the 21st of January 2025 and the delay before the hearing on the 30th of that year was not due to any of the parties mucking around. It was just one of those boring
Lots of things
logistical
going on, yeah.
things. So, in some senses, it's one of those sort of evolving things where we thought we were going to be in more quickly, but then we're not. And at what stage do you basically decide, well, we're going to wait for the hearing as opposed to going to court?
well, yes, but of course you were the respondent to the application.
Yes, it wasn't
so
ours.
You didn't have any need for urgency, whereas the applicant might have been thought to have had a need for urgency.
My lord, absolutely. What I'm trying to do is forsake what my learned friend might say and provide him with some basis for saying why they hadn't gone forward. It just wasn't a live issue, you see what I mean? And the second point was that in the December letters, it was indicated to 4 out of the 11 original third parties that they were going to be joined. But then in March, i.e. before the hearing, the remaining 7 third parties were written to say, we're not joining you now, but please preserve evidence.
Thank you very much.
And there's a witness statement from Mr. Lee's third witness statement, paragraph 33, which says that about the no intention point.
Thank you very much.
So, thank you for those explanations. We've stopped you from opening your appeal,
It's all
so
right.
please now do so.
I'm more than happy to try and answer some of your questions. It's probably academic now, but the judgment is behind tab 7 and the order is behind tab 6 of the core bundle. Permission to appeal, and you'll find that behind tab 9, was granted by Lord Justice Mayles. There's an error in our skeleton where I'm afraid we assumed it was you, my Lord Justice Arnold, that granted permission. That was a slip. The important point with respect to the pleadings before this court is that there's no respondent's notice.
Yes, quite.
Now, the way in which I was going to deal with this is that, therefore, if we win on the issue of whether or not the correct threshold was applied, then that is the end of the matter. We do not seek you, because then it's redundant, to revisit the matter. And no respondent's notice. Therefore, there's nothing before you at present to indicate that SKE wish you to revisit the matter. But that may or may not change.
Well, but in addition, there's no respondent notice contending that section 12.3 is not engaged at all.
Yes, that was actually going to be my next point. But for your lordship's note, it's contained in the judgment of paragraph 38, little Roman 2, which is in the core bundle, tab 7, page 96. Which is just as my Lord Justice Arnold has said. Now, if you wish me to flesh it out,
well, that's a slightly different point. The first question is section 12 engaged at all? But then there's the second question, which is actually a distinct question, which is whether 12.3 is engaged, as to which the position is found in paragraph 46, little 2.
Yes.
Where the judge says 12.3 applies.
Yes.
And that is not challenged by a respondent's notice.
Yes. And in the respondent skeleton argument of paragraph 41, SKE assumes, and that's the word that they use, that 12.3 is engaged. But you will have noticed from their skeleton that there is also a discussion which, on its face, challenges that assumption.
Yes.
Very brief background with respect to this case. You'll already be alive to the fact that there are a number of disputes between BB and SKE, and they all revolve around use of the word crystal in some form or other, be it in a sign or be it in a mark, and they all relate to vapes or e-cigarettes. There's several disputes, but that's it, basically. Most of the disputes are with respect to trademarks and related goodwill, but there is a separate design issue with respect to the actual physical...
Well, that's not in front of us.
No, but it's part of the overall matrix. But that's with respect to the physical plastic vape, if you see what I mean. This case is a trademark infringement case with respect to 3 particular trademarks, but again, the details are not really apposite for this court. Now, originally, SKE D1 were the only defendant, but then it was widened to include various distributors and retailers. And in October 2024, 11 letters were sent to various third parties, in essence, bringing to their attention the rights of BB.
Right. So we ought to have a quick look at least at one of those letters.
Well, the first in the bundle is to an entity called AQL, and that may be found in the supplementary bundle behind tab 19 at page 204. This is an exemplar of the type of letter that was sent, dated the 11th of October. And is accepted by all concerned that this was a permitted communication. Namely, that it does not amount to a threat.
Well, it does amount to a threat, but it's a permitted threat.
My lord, I hesitate to disagree, but the way in which the legislation, I was going to come to this in a moment, is drafted is if you write certain things, then it is considered not to be a threat. It's
all right, okay, I stand corrected. At any rate, I understand your submission.
Right, that's all I need, my lord. It's not a very interesting letter because permitted communications have to be by their nature falling within what is allowed, and so it's quite anodyne. I think to answer...
All right, can we look at one that is accepted to be a threat?
My Lord, yes, I was just going to possibly deal with a point that was subliminal within your observation, which is there's a tension between writing to people and saying, I have all these rights and I'm bringing these rights to your attention. Well, why are you doing that? And it could well be argued that that's an implicit threat.
And there's case law that supports that.
And there's 100 years of case law on that point. And that was one of the reasons why the threats provisions were amended in 2017 to try and bring all that case law together and know so that everybody knew exactly what was and was not allowed and where the line was drawn. Now, to deal with my Lord's next point is in December 2024, 4 of those 11 were then written to again, and you'll find an example on page, in the same bundle in the same tab, but at page 232. This is dated 23rd of December, and it's to Booker Limited. And this differs, and you can see that particularly in paragraph 3. The matter has now progressed as outlined below, and our client will imminently be applying to add you as a defendant. So that now crosses the border and becomes a threat that is actionable. It is accepted on all sides. That is an actionable threat. And to deal with the point that my Lord Justice Warby raised earlier, the letters are dated 23rd and 24th. They didn't all go out on the same day, but it's those 2 days. And you'll see others follow.
Yeah.
And jumping slightly out of order, what happened was that with respect to these 4, they were eventually served with a draft particulars of claim which drew them into the proceedings, and they all consented to be joined, so there was no battle over joinder. But reverting back to the chronology, on the 21st of January 2025, SKE applied for interim injunctive relief to prevent further publication of unjustified threats. And then in March 2025, the other 7 of the 11 third parties were written to, and on terms that were basically, please could you preserve evidence, and an example of that may be found this time to Asda Store, 6th of March, page 290. They're all in the same form. And again, picking up on a point that's been made by various members of the bench so far, there's no current intention to threaten any third party. That was contained in a witness statement of Mr. Lee, the 3rd witness statement of Mr. Lee, at paragraph 33, which for your note is in the supplementary bundle, tab 10, page 95. And you'll be alive to the fact that there was quite a lot of debate between me and the learned judge at first instance about why we would not give an undertaking. And the long and the short of that is I said that it's wrong in principle for the claimant to give an undertaking with respect to something that's outside of its control. Currently, when I was talking to his Lord Justice Miles, was that then, and still is the case, we didn't know of anybody else to whom BB wished to write. But it's outside of BB's control what third parties might do. We don't know whether somebody else might do something that might tip the balance. So it was wrong in principle for us to give an undertaking with respect to something that was outside of our control. That remains the case. My lords, my lady, my learned junior has done the research with respect to the 6th and 8th of May. Would you like those answers now? Is that...
If you've got them, yeah.
The 6th of May, I was wrong. There actually was a document, but the reason I didn't know about it, or rather can't remember it, it was just simply a list of people involved. So the names of the various parties who...
Dramatis persona.
Exactly so.
Okay.
And I'm afraid I probably didn't draft it and had little to do with it.
Right, thank you.
And there's also chronology is supplied as well. So my apologies for that. I didn't remember it. And the second point, the delay between the 8th and the handing down. For whatever reason, the draft judgment said it was going to be handed down on the 21st. I don't know.
Right.
Don't know why. I don't think Easter fell at that time, but I can't remember.
No, that would have been
Isn't it
Whitson. But,
Oh, sorry, my learned friend has helped me by saying he has been told that the judge was on leave.
yeah, that's the obvious explanation.
Yeah,
Right.
Someone being on leave.
yeah.
Okay.
Yes, I was trying to work out whether it was Easter, but that'd be very, very late.
It would be very
Impossibly late for Easter. Anyway, so that's the reason. I didn't think there was anything sinister behind it,
No,
but I couldn't remember the precise reason.
I wasn't meaning to imply that there was. Just
No, but
curious as to
I'm always
why.
concerned that I've missed something.
Thank you.
So that was what I was going to do by way of introduction. I think I've now dealt with all the preliminary matters. If I may, I'm then going to look at the various pieces of legislation. And the starting point is the threats provisions themselves. This may be found in the First Authorities Bundle behind tab 3. And with respect to our point, starting at page 11. Very briefly, threats in IP matters has a long history, commencing in 1883. I mean, it is 1883, not 1983, with respect to patents. It then evolved to register designs, and as time has moved on, it's incorporated and included trademarks. There's always been a tension between the threats provisions, whereby a person who has been threatened in a way that they consider unjustified can respond, and the requirement to notify people, and that tension has increased, of course, with the passing of the CPR, where you're supposed to talk first and resort to litigation last. In 2017, the provisions were amended substantially, as you can see by the number of new sections 21, capital A running through to capital F. And you get in here, in essence, a codification of what was the common law, with certain pieces of clarification, and a few new carve-outs. The new carve-out, for example, is included at 21 capital D, which is for professional advisors. (21) capital B, headed permitted communications, clarified that which had gone before as to what you can and cannot say before it becomes an actionable threat. Now, what here is the essence is that you are allowed to threaten somebody, but the mischief that this series of sections is designed to prevent is to stop unjustified threats. That is, when you don't follow through with an action. But it is not necessary to actually issue an action, because if a threat could be justified, then even if no action has been commenced, there'll be no cause of action. You can see that in section 21, capital C on page 13, subsection 2. It is a defence for the person who made the threat to show that the act in respect of which proceedings were threatened constitute, or if done would constitute, an infringement of the registered trademark. So that goes to 2 points. The first of which is basically, if you can show that it's going to be an infringement, or if it were done it would be an infringement, then it's a justified threat, basically. That's the 2 points wrapped together. And there's no actual need to sue somebody, because if you've threatened them and then the person who has been threatened complains, if in the pre-action correspondence you showed to their satisfaction, that is the threatened person's satisfaction, that it would amount to an infringement, most times they're going to back down because it would be a justifiable threat. So there's no mandatory requirement in order to invoke the defence to actually sue somebody. The next point is that this was done in 2017, which is a long time after the Human Rights Act of 1998. But as is the way, this had to be certified to be in compliance with the Human Rights Act, and that certification was duly made by the appropriate person. And we say that that must mean that it is compliant with section 12.3. There's nothing within these various section 21s that says section 12.3 is disapplied. Therefore, by signing the compliance certificate, we say HRA compliant, and that by necessity includes section 12.3.
Well, I'm not sure that's quite right, Mr. Edinburgh, because ultimately it's a question for the court whether the legislation complies with the HRA or not.
Yes. Sorry, I overstated the position. The position, therefore, would be that those responsible for placing this before
legislation, yeah.
Yes, thought that it was compliant.
Yeah.
And there's no the point I'm really trying to make is there's no carve-out that's mentioned within these provisions that says section 12.3 does not apply.
Yeah.
Therefore, we say this is in the light of 12.3.
Well, more fundamentally, correct me if I'm wrong, but my belief is that there is not a word in any of the threats provisions with which we are concerned about interim injunctions at all.
That's correct. It says, save for the fact that I think you can get interim injunctions. It's under remedies. Well, it talks about an injunction.
Yes, but that would be a final injunction.
Yeah.
So 21C1B,
B. That's
an injunction against continuance of the threat. That's a final injunction.
Yeah. Yes, that's the closest it comes, so to speak. It's silent with respect to interim relief. And the second point is that it talks about communication. You can see that, for example, in 21 capital B on the previous page, page 12. For the purposes of section 21 capital A subsection 6, a communication, permitted communications. So it talks about communications at all stages, not applications.
Yeah, I mean, I'd noted 21 subsection 1. Starting words are a communication.
Yes.
And then there's talk about a recipient.
Yes, it's consistent throughout. And picking up from a point my Lord Justice Warby has just made, in section 21 subsection 2, references in this section and in section 21 capital C to a recipient include, in the case of a communication directed to the public or a section of the public, references to a person to whom the communication is directed, indicating its breadth.
But we're not concerned with that scenario in this case, are we? These are the communications complained of in the present case are not ones directed to the public or a section of the public.
Well, they're third parties.
Yes. They're to individual recipients.
Well, that's a section of the public, arguably.
Right.
What I'd taken from that was that the legislation applies to that broad category of communication, which is the type that people usually talk of as publication in common language.
My lord.
But not only to those, because it had to be spelled out that
It applied to them.
that it applied to them.
Right, so it's wider.
Yeah.
Yeah. I was then going to take you, if I may, to Article 10, which you'll find behind tab 5, and it's on page 21, entitled Freedom of Expression. Everyone has the right to freedom of expression. This right shall include, and then it has 3 parts. 1, to hold opinions. 2, and to receive information. And 3, and to impart information and ideas without interference by public authority and regardless of frontiers. And then, because it's relevant in particular later, while we're here, Article 10.2, the exercise of these freedoms may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society. I emphasise necessary because we say that that term should be understood in the way it is understood in the ECHR jurisprudence. In the interests of national security, territorial integrity or public safety, and the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, and for maintaining the authority and impartiality of the judiciary. So that's a list of things that might affect the way in which the freedom of expression ought to be protected. But the important thing to take from that is that it includes the right to receive information and to impart information. And then if we go to the Human Rights Act, which is on the previous tab, tab 4, page 16 of the bundle, section 12, freedom of expression. It's 12.3. No such relief is to be granted so as to restrain publication before trial unless the court is satisfied that the applicant is likely to establish that publication should not be allowed. So this is the introduction with respect to interim relief interim injunctive relief, that there's a higher hurdle, and that higher hurdle is likely to establish, as opposed to the American cyanamide test, which is a serious issue to be tried, which, as you all know, is considered to be really quite low. There's very few cases that have failing to pass or overcome that hurdle. So that's by way of introduction with respect to the legislation. I was then going to move, if I may, to ground one. We say that, at least with respect to 2 of the 3 trademarks, the judge applied the wrong threshold test. He applied the serious issue to be tried, namely that contained within American cyanamide, instead of the higher threshold, likely to establish, which is contained in section 12.3. The way in which I was going to deal with this was dealing with publication first. We say that any communication to a non-originator amounts to a publication. And
Well, as I say, the judge found that 12.3 was engaged. There's no respondent's notice, so at the moment I don't see why we need to spend much time on this.
in which case, shall I just give you the references I was going to take you to, and then you have them in your notes? And
Thank you.
the first is the Lachoa case, paragraph 18, which may be found in the First Authorities Bundle, tab 22, at page 307G. That's in the context of defamation. The Assar case, paragraph 60, same Authorities Bundle, tab 21, page 287, where the point being is you don't need commercial publication, as in publication by, for example, a newspaper. And the third case is Titan, paragraph 30. It's in the second Authorities Bundle, tab 27, 409. That was a very odd case, but the point there is that there was very limited publication because it was only in essence to various individual solicitors. There was no publication at large. And that brings me back to, in this case, that if we write to only 11 people, then the Titan case certainly supports that that amounts to a publication within this context. Then, moving to the likely to establish point, this is really cream holdings, and you'll find that in the First Authorities Bundle, and the House of Lords decision is behind tab 14. Now, we've sidelined paragraphs 15 to 23, but I wasn't going to ask you to read all that now. I'm sure you've already read it. What I was going to do was touch upon certain points. Excuse me. The first of which may be picked up, may be picked up on page 158, paragraph 19, where Lord Nichols is talking about cases may arise where the adverse consequences of disclosure of information would be extremely serious, such as a grave risk of personal injury to a particular person. threats may be made against a person accused of or convicted of a crime, or a person who gave evidence at trial. Disclosure of his current whereabouts might have extremely serious consequences. Point there is that he thought it appropriate to repeat the phraseology extremely serious when he's talking about the consequences of certain disclosures and how that may affect the way in which you apply section 12.3. Then the core of what is relevant for this case is contained in paragraphs 22 and 23, and this is where he talks about the test that needs to be applied, the threshold test. Paragraph 22, section 12.3 makes the likelihood of success at the trial an essential element in the court's consideration of whether to make an interim order. And then towards the bottom, fourth line up near H, rather, on its proper construction, the effect of section 12.3 is that the court is not to make an interim restraint order unless satisfied the applicant's prospects of success at the trial are sufficiently favourable to justify such an order being made in the particular circumstances of the case. As to what degree of likelihood makes the prospect of success sufficiently favourable, the general approach should be that the courts will be exceedingly slow to make an interim restraint order where the applicant has not satisfied the court. He will probably, open parentheses, more likely than not, close parentheses, succeed at the trial. In general, that should be the threshold an applicant must cross before the court embarks on exercising its discretion, duly taking into consideration the relevant jurisprudence on Article 10 and any countervailing convention rights. Stopping there, you can see from, for example, cases like Brown and ASG, to which our attention was drawn by the court yesterday, that has been understood that at the threshold stage, to see whether or not the threshold has been passed, you take into consideration Article 10 balanced with, for example, Article 8. And that is, in our submission, a balancing exercise to see whether or not the threshold has been passed, and it doesn't affect, unless it's relevant later, to lower the threshold from the more likely than not. And then moving on, continuing with paragraph 22, but there will be cases where it is necessary for a court to depart from this general approach, and a lesser degree of likelihood will suffice as a prerequisite. Now, the use of the word necessary there, we say, imports all the jurisprudence in the European Convention on Human Rights sense, and we set all that out for your note in the skeleton argument before this court, paragraph 28.4. And continuing, circumstances where this may so include those mentioned above, colon, where the potential adverse consequences of disclosure are particularly grave. This is where the phrase particularly grave comes from, whereas the phrase that he used before was extremely serious, but in this context it must be understood that those two phrases are synonymous, or at least coterminous, or where a short-lived injunction is needed to enable the court to hear and give proper consideration to an application for interim relief pending the trial or any relevant appeal. Now, this case is not concerned with short-lived interim relief as a holdover before you can decide the interim relief matter. So that doesn't apply. So the only way in which you could lower the threshold from more likely than not is if the consequences are particularly grave or extremely serious, using the other phrase. And we say that this is not such a case, and furthermore, as a finding of fact, the judge did not hold it was such a case. And then in 23, Lord Nichols goes on to basically say the way in which this needs to be applied is to give them some...
Sorry, can I?
Yes, of course.
I assume you would accept, you were saying it's not relevant for purposes of the present case, but there's two alternatives. Firstly, consequences are particularly grave, which is the one you focused on. Secondly, urgency. This is where Lord Nichols says, or, I emphasise or, a short-lived injunction is needed to enable the court to hear and give proper consideration to an application for interim relief. So that's talking about where it's perhaps a without notice application or without notice on notice, as it's sometimes called. But in other words, it's so urgent you don't have time.
Yes, I mean, absolutely.
But you would say this is not such a case.
Exactly. There was no application for ex parte relief, or however you want to put it, before the hearing for the interim relief. And the explanation for that and justification for that is that it would be completely ridiculous, for example, in the case of confidentiality, not to grant the relief at the first ex parte hearing, because that would destroy the subject matter in essence, and so make a nullity of the second hearing. And it's actually been extended further than that. It comments with respect to, even if there has been no injunction granted at the interim relief, you should grant a short-term injunction if it's going to appeal, again, to maintain the subject matter. But that's not the case here at all. So therefore, we say the only way in which you can alter the threshold, the higher threshold, and reduce it to a lower threshold, is in essence by satisfying that the matter is particularly grave.
The language is not exclusive. At the end of paragraph 22, it identifies those two, but it identifies them as circumstances where this may be, so include.
Absolutely.
So there may be other circumstances, they're not spelled out.
I'm definitely not saying, well, what I am saying is that it is inclusive as opposed to exclusive language, but the way in which you would need to find something that satisfies the requirement to lower the standard is it has to be of the same sort. And so it's clearly, in this case, not the same sort of seeking an urgent injunction.
I don't think, I'm not aware of any cases in the last 20 years that have identified a third or fourth category.
No, but I wouldn't like to exclude it.
But there may be other circumstances
Yes.
that haven't yet been identified.
But in some senses, Lord Nichols expressly said that because he said it was flexible. I mean, he said that several times. So he does want to maintain flexibility for things that have turned up that he hasn't thought of. But with respect to the particularly grave point, there's quite a lot of things that have already expressly been mentioned there. And we say that if there is a third, completely different category, it hasn't been identified. The way in which we say this case has been argued is that purportedly the damage in the threats matter is sufficiently grave so as to fall within that second category. And we say that was not the finding. And in any event, this is against the backdrop of the fact that these are exceptions to the general approach. Now, in the ASG case, which was drawn to our attention yesterday, paragraph 4, it explains that the way in which you balance Article 8, Article 10 is with whether or not the higher threshold has been met. And that accords, for your note, with Brown, paragraph 43, which is in the Authorities Bundle 1, tab 17, page 201. But Article 8 is not relevant here. What is raised is a Protocol 1, Article 1 point about rights in property, quiet enjoyment. And it's appropriate, therefore, to take you to that, which you'll find behind tab 5 in the First Authorities Bundle on page 23. Part 2, the first protocol, Article 1, protection of property. For every natural or legal person is entitled to the peaceful enjoyment of his possessions. No one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law and the general principles of international law. The preceding provisions shall not, however, in any way impair the right of the state to enforce such laws as it deems necessary to control the use of property in accordance with the general interest or to secure the payment of taxes or other contributions or penalties. Now, it's not entirely clear how this is put in SKE's arguments, but if the quiet enjoyment relates to the branding upon SKE's products, then we are in a little bit in the Alice in Wonderland category here. The reason for that is, indisputably, there is a property right in registered trademarks. For your note, you will find that on page 9 of the Authorities Bundle, subsection 2.1. A registered trademark is a property right. But if there's an infringement, then there can be no property owned by SKE, because that is then an alleged, an infringing sign. So there's no property owned by SKE.
Well, I don't quite understand that section. Why does infringement mean you have no property right? I mean, surely the real question is whether there's a property right in the first place. And the extent of the law, so far as I'm aware, is that registered trademarks are property, and the Court of Human Rights has told us in Anheuser-Busch that an application to register a trademark is also property.
Yes.
Or, sorry, a possession within A1P1. Let us be accurate. But I'm not aware of any jurisprudence of the Strasbourg Court that says that a sign is a possession. It's got nothing to do with whether it's an infringing sign or a non-infringing sign.
Well, the sign, certainly under the law in England and Wales, a sign per se, which is not registered, is not...
Nor applied for.
No, nor applied for is not a property right. The case law on that would be the Singaporean case. The point being is that
But that is, Star Industrial tells us a proposition that was established prior to that, in fact, in Spalding and Gamage, that goodwill is property.
That's what I was just going to say.
But so what?
Well, what I'm trying to draw as a distinction is that the property in that case is in the goodwill, not in the unregistered trademark or the unregistered sign. So that supports your point.
At the moment, you're shadow boxing because you don't know what the case is you're trying to meet. I suggest you deal with it in reply.
My lord. Yes, I was shadow boxing because I was raising something which I thought might arise, but I'm not quite sure how it's going to be put. So, my proposition is that, assuming for the moment, the way in which this case is being put is it falls within the second category of potential ways in which to lower the threshold, i.e. the particularly grave category. We say that that doesn't work, and that's what the finding of the judge was. And there's a case which does deal with this tangentially, and that's the vet plus case. And you'll find this in the authorities bundle, the first authorities bundle at tab 16. And the critical part is at paragraphs 48 onwards, 184. Now, I need to put this slightly in context. This was a trademark case in the sense that it was a comparative advertising case. And the comparative advert to which complaint had been made basically said that Boehringer's product did not contain the active ingredient to the extent that was claimed by Boehringer. Now that is an incredibly serious allegation. It's basically saying Boehringer are putting out packaging on their product and saying that it contains a certain amount of active ingredient, and it does not. And so there's little that could be more damaging to the reputation. Now,
it's not directly relevant, I don't think, but in case it comes up later, can I check that my understanding of the timing of this decision is correct? This is June 2007. So my understanding at the moment, subject to correction, is that chronologically speaking, it comes after the Court of Appeal decided in O2 and Hutchison to refer to the Court of Justice the question, in essence, to put it simply, as to whether comparative advertising could ever be trademark infringement, and the subsequent decision of the Court of Justice to say, yes, it could. Now, that's a very short paraphrase of a complicated issue, but what I'm interested in the moment is the timing.
So my learned juniors checked all this. O2 was referred in 2006 and decided in 2008.
So my understanding is
correct. So your chronology is correct, Mark.
Yeah.
The next point, which I think is inherent within your observation, is that Lord Justice Jacob considered that comparative advertising was potentially trademark infringement. And that was shown to be the case after O2 came down.
Okay.
And paragraph 48, page 184, behind tab 16, through to paragraphs 52 substantively, is that he considered in this case that the threshold in section 12.3 was not lowered. So therefore, you must have considered that in this case, which we say would be a particularly serious matter to impute the reputation of a company like Boehringer, that it, in essence, was misleading people with respect to the content of its active ingredient on its packaging. If that sort of serious allegation did not lower the threshold, then likewise here, there's no lowering of the threshold. Because, for example, it doesn't align with the sort of examples that were given by Lord Nichols, such as imminent threat to life, where the consequences are particularly serious, especially serious. And you can see, for example, in paragraph 51, where Justice Jacob has in mind expressly the point about particularly grave, because he refers to that phrase in the second line of paragraph 52. Now, this is also relevant because it deals with, in essence, a trademark infringement matter, which is akin to here, but it also therefore means that it deals with a commercial matter, which is akin to here. So section 12.3 is not limited to things like pure defamatory matters, personal reputation, or what have you, but it also extends to commercial communications, in this case between two commercial entities trying to sell a product that dealt with or addressed the health of dogs. And here you have a commercial dispute between people who are trying to sell e-cigarettes. So on those grounds, it's all aligned with this case. And that's why, even though it's a comparative advertising case, not a threats case, it's still relevant by analogy. And so, I mean,
well,
in essence,
Justice Longmore makes a point in paragraph 55. There can be little doubt that the right of freedom of expression is engaged, even though the dispute is strictly speaking a commercial dispute. So he goes directly to the point.
Yeah. Yes, I have that highlighted in my copy, but it's not sidelined. So that's why I didn't take you to it expressly. But yes, I'm grateful, my Lord. So what you have here, bringing these threads together, is that we say that Article 10 applies, Section 12.3 applies with respect to interim injunctions. It's important to note that Article 10 is at least twofold with respect to imparting information and receiving information. The standard test, as in Cream Holdings, is basically a higher test than American cyanamide. You can change that threshold, but in order to do so, you need to fall within a narrow group, non-exclusive narrow group of things, exceptions. This does not fall within that narrow group of exceptions. And by analogy, VET Plus shows in this sort of trademark dispute that these sort of trademark disputes do not fall within the exception. Therefore, the higher test applies. And as the judge held with respect to at least two of the three marks, only the serious issue to be tried threshold had been crossed. He applied the wrong threshold. Therefore, the interim injunction was granted on the wrong basis. Therefore, we say it should be discharged. That's my ground one. Any questions from anybody?
No.
No. Ground two is really very short. It's basically, with respect to one of the marks, this is crystal clear Vapors electronic cigarettes, which is the 344 mark. In the judgment at paragraph 89, the judge held that it was a realistically arguable case. Now, arguing against me, assuming that that's a higher threshold than the American cyanamide test, one could then say that he's properly reasonably satisfied that section 12.3 is met. the threshold is met, and then you're allowed to go on to consider the discretionary points, and he found those against the appellant. But with respect to the 551 mark, which is the crystal addict case, and the 148 mark, which is the crystal bar case, he held that there was only a serious issue to be tried. You can find that in the judgment at paragraphs 88 and 89. And we say, therefore, with respect to at least those two marks, it's clear on the finding of fact that the higher threshold was not passed. Obviously, this is dependent upon the higher threshold being applicable. But therefore, there was no proper basis to injunct those two marks, and even less basis to injunct marks that were not before the court. Let me just make that point good. In the order which you'll find behind tab 6 in the core bundle, and on page 83 of the core bundle, paragraph 1 is the injunction. The opening parts of paragraph 1 show that the threat has to be made in respect of goods supplied by the first or second defendant. That's to ensure that the first or second defendant is an aggrieved party, which is a necessary requirement for the threats provisions to be invoked. And then you get the 344 mark, which is the one I've said had a realistically arguable case. But then you get the crystal addict and the crystal bar marks. But in 1D, any other registered trademark or application for a trademark which is presently owned by the claimant or which the claimant acquires in the future and which is relied upon by the claimant in these or related proceedings. There's been no determination there at all with respect to that last bit.
Where is that subject matter dealt with in the judgment?
It's not dealt with directly. It was more argued when the form of order came before him on the 27th.
Right, in which case one would assume there's something about it in the form of order judgment.
Which you'll find behind tab 8. It's paragraph 2. And further down, with respect to the permission to appeal, paragraph 9. And then dealing with this, so to speak, from another direction, is that even if an interim injunction could be granted with respect to the 344 mark, it makes no sense as a matter of reality to injunct one out of the 3 marks. Because if you can still continue to threaten with respect to the 551 mark and the 148 mark, the way in which a recipient would act, we say, would be predicated upon the most fearsome of those threats, and any damage would flow from the most fearsome of those threats, which would be encapsulated in the 551 mark and 148 mark. And so it makes no sense at all to injunct with respect to 344. So it's just a matter of practicality.
Well, it's not just practicality. Your submission is there's no damage to be restrained over and above.
Well, yes. I mean, sorry, yes. Because no damage.
You say
there'd be no causation. Sorry to cut across.
yes, no causation. Exactly.
Yeah.
All right.
My lord, my lady, unless you have further questions of me.
No, thank you very much. It's not.
My lords, my lady, I intend to deal with matters in the following way. Firstly, give a very brief overview of the respondent's position on this appeal. Then secondly, go into a short but essential focus on the facts of this case as found by the judge. Thirdly, and this will be the main focus of my submissions, the law and threats, section 12 of the HRA, Cream Holdings, and our position on that. And then finally, and this will be very brief, just tying that together in grounds 1 and 2, but most of my comments on grounds 1 in particular will be carried out as we go through the law. So dealing first to the brief overview of the respondent's position, there are, we say, two ways to answer this appeal, a short way and a more detailed way. The short way is simple. The test proposed by Lord Nichols in Cream Holding explicitly states that there is flexibility in the threshold to be applied, depending on the circumstances of the case. Those circumstances include, of course, the degree to which Article 10 is engaged. The judge, we say, exercised that discretion, and given this is an interim decision, no appeal that he exercised his discretion in an unreasonable way has been advanced.
Sorry. I'm sorry to jump in when you're only just starting, but I must ask straight away, is it your submission that the court has a discretion as to the threshold to be applied?
Our position is that Cream Holdings gives a degree of flexibility to the test that is applied. It is not always a more likely than not test, i.e. above 50%. And that the flexibility or the discretion is based on the particular facts of the case.
Yes, but you've reiterated the word discretion.
Yes.
And that's what I want to be very clear about. And I'll repeat my question. Is it your submission the judge had a discretion as to the criterion to be applied?
He had no discretion as their criterion to be applied and that he had to apply the test in Cream Holdings. But we say Cream Holdings gives a flexible test depending on the facts of the case, and it is at that point that his discretion is engaged, because he is able to look at the facts of the case. And perhaps the easiest point to see how he summarised this up is in the consequentials judgment. Maybe just jump there, given we very recently looked at it, my lords, my lady. That is at tab 8. Page 111. Where in paragraph 8, this was in relation to the permission to appeal application, he said that he decided this case on its particular facts, taking account of the very limited impact of the proposed injunction on C's activities and the potential damage to D1, and then concluded that in those specific circumstances the merits were sufficiently strong to justify the imposition of the injunction. And then goes on to note that he took account of the exceptions in the proposed injunction, part 3.
So the first point there is he doesn't say that he thought he was exercising a discretion.
I accept that it's not exercising discretion in the normal way that we use that on appeal. I guess I should keep to the use of the word flexible. He had a flexible test that could be applied depending on the circumstances of the case, and he exercised that flexibility.
Is that what you say Cream Holdings held was Parliament's intention?
Yes.
Because one of the peculiarities of Section 12.3 is that it's a jurisdictional threshold. You may not, the court has no jurisdiction to grant an injunction unless the likelihood threshold is passed.
Correct.
So the consequences of giving a judge a flexibility that depends on what the judge thinks are the merits of the particular case, or what he thinks or she thinks is sufficient in the particular circumstances to justify an injunction would be to, arguably, to undermine any effect of that jurisdictional bar, because it's just saying don't grant an injunction unless you think it's appropriate.
My answer to that would be that the Parliament's intention was that there had to be a degree of flexibility, and that is particularly so when we get on to the question of threats. There's something I'm going to go through in some detail when I get there, is there's considerable discussion in the materials, in the Law Commission materials, repeated references to the presence and indeed importance of interim injunctions. Not a dicky bird about 12.3 entering at that stage. And of course, this was in 2017, long after Section 12.3. Now, it may well have been correct that we have all been labouring under a misapprehension for the best part of 25 years. But as I will come on to address in due course as well, the proposed scope of communication proposed by the appellants in this case would have consequences that 12.3 would be engaged in other circumstances that we say cannot have been the correct parliamentary intention behind 12.3, and certainly not the correct parliamentary intention behind the amendments brought in 2017 by the threats provisions.
Thank you very much.
So the short answer, we say, is that there is a degree of flexibility, and he exercised that in light of the facts of this case. The longer, or should I say more detailed answer, is that as I go through a fuller analysis of the threats regime first, followed by Cream Holdings in Section 12 and Section 12.3, that the judge was correct when one considers this further detailed analysis. Underpinning all of this, of course, is the fact that the threats rules, the threats regime, which dates back, as my learned friend has said, to 1883, have always been there to address this, the phrasing that often gets thrown around is willing to wound but afraid to strike, because threats have a particularly pernicious effect, not only on the recipients potentially, but also on the person whose goods or services the recipients are providing. In this case, we say is an opposite test case to establish the proper boundaries of when an interim injunction can be granted in a threats case. Because this, as I set out in my skeleton, is at the more extreme end of conduct for setting out threats based on the findings of the judge that I will come to, given that they wrote off to at least 7 individuals they weren't willing to follow through on. They were sent out on Christmas Eve, and barely any time was given to respond to it. And the obvious consequence of that is that any of those who wish to be emboldened to weaponize the threat's power, and it undoubtedly has a power to send a threat to somebody, will be significant if the appeal is granted. And that, we say, cannot have been the intention set down by Parliament. So turning then to the second of the topics I wish to address, is the focus on the facts of this case. My lords and my ladies, as I foreshadowed in my skeleton, it's all too easy to get pulled in on appeal to a detailed analysis of the law and lose sight of the touchstone facts that were found at first instance in this instance. And the importance of those facts is that, given the flexibility that Parliament envisaged, the judge's view of those, having had time to consider them, should not, we say, be touched on appeal. BBL and SKE are competitors in a market that is worth over $400 million per annum in the UK alone to my client. So the interference with that market, one can see, will be quite significant. Indeed, this is a situation where the appellants have had to had to go and get ATE insurance because they weren't able to stump up security. And that's one of the factors that...
So what?
Well, the consequence of that, of course, is that if no interim injunction can be put in place, threats can be made, an action brought, damages, if my client is successful, in due course paid out.
So where does the judge rely upon ATE insurance as part of his reasoning?
So he doesn't rely on ATE insurance because ATE hadn't been put in place, but what he does say is that they had chosen not to put in any financial evidence at all that could justify them being able to satisfy any damages in due course. Since then, there has been ATE insurance put in place. So turning then to the facts as found by the judge, I'd be grateful if you could please turn to tab 7. So the case was issued against my client on the 18th of September 24, and in October 24, Brown Smith's solicitors from BBL wrote to 11 of my client's distributors and retailers. The judge records at paragraph 11 that those letters were sent and my client was notified before of the intention to send those letters, but my client was not shown copies of those letters. And that's recorded in paragraph 11. My learned friend has taken you to the letters, so I do not need to do so. The judge also records in paragraph 11 that those letters, and this is now talking about threats letters, the one sent in December 24, he records that those letters would be sent unless SKE, my client, agreed to mediate. Now, SKE did in fact agree to mediate, but as the judge records, BBL sent those threats letters anyway.
So I'm not understanding. That comment seems to be directed to the October letters, which are accepted to be permitted communications.
Yes, sorry, that is correct. I've got my dates wrong on that. So they said that they would mediate. They wouldn't send them if mediation was agreed. Mediation was agreed, and they sent them in any event. Now, those are permitted communications. That does mean, as my Lord Justice Arnold pointed out, they are threats under the way it's defined in the Act, albeit that they're then carved out. So it is a threat because it's implicit in it.
Yeah, so your position on that is straightforward. You say it's a threat, but it's not an actionable threat.
Precisely.
Yeah.
So, yeah. Then, of course, the 11 threat letters were sent out on the 23rd and 24th. I think the way my learned friend said it, though, I don't think he meant to say this was the case. There were 11 letters sent out on those 2 days, not just the 4 to those that were followed through. All 11 were sent out. And then the judge also records at 14 that it wasn't until the hearing that it was confirmed to my client that no other letters had been sent. And that's relevant because part of the relief that my client sought was disclosure or provision of information to tell them to whom else letters may have been sent so that they could, potentially go and do something about it. And he records at the end of paragraph 14, and I'll just read it out, he says, "This should, to my mind, have been spelt out more clearly earlier." And that lack of candour, of course, continued the period in which my client was somewhat in the dark. He then records in paragraph 16 of the judgment, that the Brown Smith's letters on behalf of BBL stated all 11 would be brought in, and those stated they'd be brought in imminently, but of course 7 of the 11 were not. And again, as the judge records in the judgment, there are 4 companies that were brought in, but really it's only 3 because 2 of them are related entities. Now, jumping then on to paragraph 77, just to point out here, he is clearly, and this goes to the severity of what the judge was considering. He says that, on the other hand, as a feature of the cases of unjustified threats to secondary parties, the damage to parties aggrieved will often be sudden and grave. Now, I accept the judge doesn't say as a finding explicitly that the harm caused by these threats is grave, except he doesn't say that. But it's quite clear when you read his judgment in its totality that he regarded the damage as being very serious. He talks about sudden, serious, and severe, I think is the phrasing. I'll check that in a second. But he clearly does use the word grave here, and then clearly has that at the front of his mind. So it's clear from a fair reading of his judgment, he did think this was particularly grave or very serious. But I accept, as I said, he doesn't use the specific words. Then at 81 onwards, we get into his assessment of the evidence and its conclusions. And if you could please jump to paragraph 93 on page 105. Here he held that BBL had made it clear during the hearing they wished to preserve their right to threaten further parties without giving any advance notice to my client. And then in 94, he takes account of the fact that BBL's evidence simply did not explain or seek to justify the decision to ratchet up from permitted communications to threats. Now, just pausing there, we accept that permitted communications have a particular importance with regards to secondary infringers. Because, of course, a secondary infringer may need to be put on notice of rights. That's what the purpose of permitted communications is for. So that any secondary infringer, i.e. not the maker or the importer, the primary infringer, can still be fixed with knowledge as of the date of permitted communications. And of course, the injunction that was granted by the judge makes no restriction on permitted communications. And again, as I said, he emphasizes this fact that there has been simply no explanation or justification as to why they needed to go above and beyond the permitted communications.
Can I just ask this about 94? The judge finds towards the end of it that the inference is, the obvious inference is, that the further letters were written with the commercial motive of seeking to disrupt SKE's route to market.
Yes.
I would have thought that was almost invariably the case. That's what this is all about.
Yes.
People competing for customers.
Yes.
So that's what threats letters are for. Is it in your submission a finding of importance?
Yes. Well, you see, the purpose of threats letters, as I said, there is a necessary need for letters in the sense that you have to be able to send a permitted communication to put them on notice of rights, because that may have consequences down the line, both in terms of infringement and potential level of damages, remedies, etc. And there is, I accept, a slight tension that the judge does deal with this, of the requirement under the CPR to send letters before action. But of course, as I will come on to when we go through the law and the background to the law, it's very clear that the ability to write to somebody with a property right, particularly a registered property right, can cause significant and serious harm. And that, of course, is the ill at which my client is seeking to stop any further harm of that sort. And there's a commercial motive to doing it.
Can I rephrase my Lord's question in a slightly different way? Is it your submission that threats are always particularly grave in their consequences? Or would you accept that it's necessarily a fact-specific assessment?
I would have to accept that it would be subject to assessment in the facts of a given case. The judge does, I think, I'll check again, make the finding that they will almost always fall into that category, but I do accept that it would be on the circumstances of the case. The particularly egregious factor here, we say, is that they were written to 11 parties with no intention to ever follow through on 7 of those 11 that they threatened. And those were big players, people like
That's
Elisabeth.
not the finding of the judge, is it? It's a fact that they didn't follow through.
Yes.
It's a step beyond that to say that they had no intention to follow through at the time they made the threat.
No, I accept, and he doesn't find that they didn't have an intention to follow through at the time, but he does then say the obvious inference, as you pointed out, is that there was the timing of the letters and the seeking of the undertakings. They were...
Well, I'll just say, what puzzles me about this is that you've got someone who's claiming rights and someone who's on the other side trying to compete with them. You might say, well, it's disproportionate or unnecessary to write these letters to these people, and look at what you did, you didn't follow through on those claims. But isn't the real issue whether the claims are justified or I mean, in a threats case, the real issue is
Ultimately, that is
justification.
the real issue that is to be determined down the line. The point, of course, of the interim injunction, and I'll come on in more detail, as I said, when we go through the law, is that, the long-standing reason why threats have existed under English law is that they can cause a very pernicious type of damage. Because, of course, one can easily see why Sainsbury's, Asda, whomever it may be, may receive a letter and think to themselves, I don't want to get involved in this. I'm just going to pull it off the shelves and crack on with my life and not have to worry about this. It's a small product. I don't really care. And the person whose products have been taken off the shelf, of course, A, may not know about that. And it may have been unjustified in due course. But the damage that is so pernicious in threats case happens at that outset.
Yeah. Well, when you come to it, what I'm interested in is why the more likely than not threshold is a problem there.
Yes.
I can see that there are lots of cases, and Cream Holdings is one of them, where the damage caused by the alleged tort would be severe. So there's all sorts of reasons to impose an injunction, but at the moment I'm not very clear why it's inappropriate to set a standard of, well, show me you're going to win, which does apply in a whole range of other categories of case where, even on your case, they are publications.
Well, and I'll come to that in due course, there's no doubt you'll be all very keen to hear.
Can I just ask a slightly different question while we're on this general theme? The judge records that there was evidence that your client had to offer indemnities to the suppliers and retailers in question. Am I right in understanding was that there was no evidence that any of the distributors or retailers had stopped dealing in your client's products?
There was no explicit evidence of that now.
Thank you.
Of course, it was also a relatively short time after, and of course, stock is ordered in advance. But just to answer my Lord Justice Warby's question now, so you see where we're going on this. My client's position is that to prove more likely than not in an intellectual property threats case, where you're going to have to consider validity of rights almost invariably, the question of infringement, the average consumer if it's in trademark matters, as well as a whole host of other disputed factual contexts, mean that at an interim stage, it will be almost impossible, not always, but almost impossible to satisfy that case. And that is particularly true in patent cases, because of course this doesn't just apply to trademark threats, but also would apply to any threat made in relation to a patent. And every patent dispute that I've ever been involved in, and Lord Justice Arnold has obviously many more than that, will have no doubt involved expert evidence. And there is simply no way that in relation to a threat made patent threat, that at the interim stage, that the aggrieved party would be able to satisfy the court that they are more likely than not to win, except there might be some extreme cases. But realistically, it is not possible, given the myriad factual and legal disputes, for this ever to be resolved at an interim stage in any of the threats actions, which all, you can actually have threats in relation to unregistered rights.
Yeah. Well, thank you. That's very clear.
But particularly in relation to. So we just say realistically, if that is the test, it won't ever be capable of being satisfied, save in an extreme, extremely obvious case. The judge then records in 95 that since making the threats, BBL had chosen to only add a limited number of the parties to the proceedings, and he was unable to accept one of a friend's submissions that it had reasonably decided to join a representative sample of suppliers and retailers to reserve its position against others into the conclusions of existing proceedings. He concluded, and you can see this.
Can you explain to me, because apparently what they did wrong was joining too many defendants. What's the logic of that?
Sorry, my lord, I was reading something. If you could repeat your question.
So apparently what BB did wrong was joining Tesco and Morrison's as defendants when they didn't have to. And I'm asking for elucidation as to why that's wrong and what the relevance of it is.
Well, one of the issues that the judge had was why, and he was pushed my learner friend on this a number of points during the hearing, why these people had been threatened. And one of the answers that came forward is that they were being sued as effectively representative defendants, so that there was somebody at a different part in the retail chain, so that in due course, that if they had managed to establish infringement against a retailer and a damage inquiry against a retailer, that could be used.
I'm sorry, we seem to be going off track here. Let me try and be a bit more specific with my question. What I was focusing on was the two sentences in the middle of paragraph 95. But it has joined both Tesco and Morrison's as defendants. BB did nothing to explain this. This seems to imply that BB has done something wrong which it needs to explain. And I'm asking you for your submission as to that, because at the moment I'm puzzled. Because, as you yourself pointed out earlier in your submissions to us, what the threats legislation is directed against is those who are willing to wound but afraid to strike. There is nothing wrong with striking.
Absolutely.
And in joining Tesco's and Morrison's as defendants, it might be thought that they've done what they should have done. And therefore, asking for there's nothing wrong, and certainly there's nothing that requires explanation.
What this is coming out of is that an answer was given by my learner friend to the judge as to why they had sued whom they'd sued. And the answer came back that it was to give representative samples. And what the judge is saying here is that answer doesn't make sense, given that two supermarkets were sued. I
just don't understand it, because a claimant is entitled to sue whichever defendants it wishes to, correct?
Yes.
And insofar as it does join defendants, there can't be any criticism that they're willing to wound and afraid to strike.
Of course.
So why is it problematic that they have joined Tesco's and Morrison's as defendants?
So it's not problematic that they've joined Tesco's and Morrison's. It was the fact that because they had joined both of them, it undermined the submission that my learned friend was making, that they'd picked people to create a representative sample out of the 11 that they had threatened, because the judge was trying to find out was there a real, genuine commercial rationale for these threats letters, or was it purely to cause commercial harm? And one of the answers that came back is, well, we sued who we sued because we wanted somebody at different levels in the chain so that we have a sample defendant going forward. And the judge looked at that and said, well, that answer doesn't make sense because you've sued two people at the same level of the chain. You don't need, if you've picked this subset because you want representative defendants, then that answer doesn't make sense because you've picked two representative defendants. And
suppose they sued all of them. Let's imagine they sued all 11.
Yeah.
Then that would have equally been relied upon as undermining their explanation on this theory, and yet there could be no objection to it.
Quite. I totally agree, my lord. And what I'm saying here is that my client was wondering in that interim period, post the issuing of the interim injunction through to the actual hearing, would all 11 be sued? Because if they had been sued, it would have been considerably more difficult for my client to then turn up and seek the injunction to continue. What the judge was trying to find out, because it wasn't addressed in evidence, was why. What was the rationale for sending out these letters? And the answer that came back to him was that they had picked a representative sample. And the judge didn't accept that submission, as you can see in the second sentence.
Yes, but that presupposes that the 11 is a selection from a larger sample. And where's the evidence of a larger sample?
Well, I don't think it was. There are numerous retailers, corner shops up and down the land that sell my client's products. These are in not going to say every corner shop in the land, but in many and many.
Well, to be sure, of course. But where's the... Sorry, let me rephrase. They didn't write to anybody other than the 11.
That's correct.
Right. So was there evidence, or maybe I need to rephrase my question, did the judge find that there was a threat to sue more, there was a threat to threaten more than 11, to which this point about suing Tesco's and Morrison's would be supportive?
No, he didn't make that finding.
Right.
All he was saying here, my understanding of what he's saying here, is that the judge was very keen to understand what was the rationale behind this. Were these genuine letters before action that were sent out with an intention to follow through and sue that party? Because, of course, the threats letters, the further letters that were set out in January, I'll come to one of those in a second, said to all 11 that they would be imminently joined. And that's what the judge was particularly concerned with. Why were these letters sent out? Because if they were genuine letters before action that were genuinely followed through, it would, of course, been much more difficult for my client to get any interim relief. The judge clearly thought that those letters were not genuine letters before action sent out with a genuine intention to follow through. And that's why at the hearing, and the transcript references to this are in our skeleton, that's why at the hearing he was pushing on this factor. Why have you only done a subset? Surely if you sent letters before action to everybody, you would have sued everybody. And the answer came back, they have picked a representative sample. And the judge says that logic doesn't stack up because you've picked 2 people at the same level of the chain. And there was never any explanation as to why the others weren't sued. And then, as my Lord Justice Warby, he concludes paragraph 95 by saying that no convincing explanation has been given for the selection of parties it chose to threaten but not sue, i.e. the other 7. This supports the view that the December 2024 letters were commercially motivated, i.e. they were commercially motivated to cause harm to my client. They weren't actual letters sent with an intention to follow through legal proceedings as required if you wish to sue somebody under the CPR.
If a person behaves in a bullying way in the exercise of an undoubted right, is there a jurisdiction to restrain that through the threats litigation?
It would be through the interim injunction initially, and then potentially, yes, if the threats were unjustified.
But, if they've got the right, they genuinely believe that it's being threatened, but they behave in an excessive and disproportionate way, threatening litigation and then not carrying through. Would that be a ground for granting a threats injunction? This is a genuine question. It's not.
I mean, it would depend on the circumstances of the case, but there is provision certainly under copyright law for what's called a put up or shut up order, that if you are out there making threats against people, that you can be forced to go to court and are told to actually go ahead and issue proceedings or not. So I guess that jurisdiction that I'm only aware exists under...
I'm not familiar with that. I'm not questioning what you say, but I'm not familiar with that because the threats legislation doesn't apply to copyright.
No, it doesn't quite.
So what I'm really asking is if the ultimate issue on the merits is were the threats justified, and the ultimate conclusion was yes, they were, because there was a right and there was a threat to infringe the right, and so there was a basis for threatening litigation, whether it was carried through or not. Would the fact that the behaviour was bullying and unjustified in the way that the judge is describing it be a basis for granting a final injunction?
I don't believe it would be the basis for granting a final injunction if it was justified.
Yeah.
But I can see.
So what this leads to,
Yeah.
it seems to me, is that the judge has not found that the threats are unjustified. He says they might be.
Yeah, and he can't make that finding.
But they were made in a bullying way, and there's a risk of damage, and it doesn't. The exercise in assessing the damage either way.
Yeah.
And it's on that basis the injunction is granted.
Yes, effectively he's saying that these letters, what we say he's finding at the end of 25, is that there's a commercial motivation for sending out these letters that was a commercial motivation to interfere with my client's property rights. Their actual goods on the shelves will be taken off the shelf potentially, and that was the intention behind writing those letters to those 7, and not a, I am complying with the CPR because I intend to sue you. And of course, this is another reason why at an interim stage it'd be very hard for a party in my client's position to ever convince a judge that this is exactly what they intend to do, because it's obviously a matter for inference, but the judge was willing to go that far on the inference here.
Yes,
And
thank you.
in relation to my Lord Justice Arnold's question about the put up or shut up in order, that was the reason I'm aware of that, is that was the basis originally of the relief in Coppa and Wright. And there is a case that if needs be I can dig out and send later on, but there was one earlier decision, I can't remember which judge it was, the name has escaped me, but basically said if you go around, and it was in relation to copyright, if you go around saying to everybody that you're going to do something, you can be forced to actually put up or shut up, and it was that basis on which the entire Coppa and Wright case was sprung off, because in that case the concern was that Coppa and others had been threatened, but they wouldn't actually be able to do anything about it. But I'm not aware of that case existing in any other area, and the threats, obviously the threats provisions don't exist in relation to copyright. And then in 96, he goes on, again, taking this point further about the representative retailer, supplier, and wholesaler, and says that on their suggestion, this is in the last sentence, or maybe the sentence before, so that the sentence beginning hence, says, hence on its own argument, it, i.e. BBL, has no reason for joining anyone else into the proceedings themselves. It has joined each kind of representative defendant it needs. This suggests that if it does choose to threaten any further secondary parties, it will do so without the intention of joining them into proceedings. So again, he is clearly concerned about the lack of explanation evidence as to why these other letters before action were sent out threatening proceedings without ever actually following through. Very, very, very much willing to wound, but failing to strike.
But does that matter if the underlying threats are justified?
Well, ultimately,
Is this the judge treating these sorts of issues as a proxy for the real question, which is whether or not the threats were in fact justified?
no, I don't believe he is treating it as a proxy for whether or not they're justified, because it was accepted by all sides that actual determination cannot be made at an interim stage.
Mm-hmm.
And then just a few final points to draw your attention to from the judgment. Paragraph 99, very end, he goes through that about the adequacy of damages and the difficulty to assess damages to my client. And he also notes it'd be very difficult for my client to find evidence on the link between threats and losses. As when we come back to look at, we come to in a second to look at the background to the law, you can see that as a particular concern with threats and the pernicious nature of them. It can be very hard to go out and find why a particular supermarket or retailer or distributor has pulled something from their shelves and the reasons behind that. The causation issues become mixed and tricky, to say the least. And then in paragraph 100, he records there's no evidence before me about the ability of BBL to meet any claim for damages. BBL has chosen not to exhibit any financial statements or even describe its own financial position. I'm unable to conclude that it would be good for any significant damages. Now, I appreciate that's going down into the later limbs of American Cyanamid, but it does show the particular problem that arises here, in that this is a set of facts where letters have been sent out to my clients, some of my clients, retailers and distributors, in a market that's worth hundreds of millions a year, in circumstances where if at the end of the day my client succeeds at trial, they're facing a company that has had to go and get AT insurance because they couldn't even satisfy security for costs, and they chose to put no evidence in. So a very pernicious ill can be inflicted on my client with potentially no recourse down the line. And then there's one final point again, which is, goes to my Lord Justice Warby's question about why can't we just do the more likely than not test at the outset, which is of course that both in relation to trademarks and in relation to patents, you can issue a threats letter in relation to an application. But of course, in those circumstances, if it's subject to an opposition in the IPO in a trademark or a patent, it could be many, many years before that is actually finally resolved down the line and the client can get potentially some money back.
Yeah, but this isn't a trial.
No.
It seems to me that this argument that you can't work out who's likely to win presupposes that the process of deciding that is akin to a trial. Obviously, Parliament didn't intend, in any case, that Section 12 would require the court to conduct a trial. It's put the court in an unusual position in this sphere of interim injunctions, saying you can't grant this injunction unless you've been satisfied by the claimant that they are, in most cases, probably going to win. And in the sphere of litigation I'm more familiar with, judges have become quite familiar with making decisions on what are sometimes, no doubt, less complicated than patent cases, but quite complicated cases where the facts may concern whether a serious allegation is true or not. Not usually in libel, because that doesn't come up that way, but whether a disclosure of otherwise confidential information is some way merited by public interest. So it does get done in other spheres without cross-examination, expert evidence, and all the rest of it.
It does, my lord, except in those areas. Our position is that in relation to the context of intellectual property claims, particularly if we're going to have to gauge the question of expert evidence, it would become very difficult to have anything other than a mini trial. And it may well be that post this decision, depending on what your lordships and your lady, my lady decides, that there may have to be a change of practice in this regard and some form of mini trial to some degree.
Lord Justice Jacob didn't seem to think there was a problem in Vape Plus.
Well, I'm going to come on to Vape Plus in due course, my lord.
But all of these practical problems are recognised in the American Cyanamid decision, which establishes the general rule that you don't have a mini trial. You show a serious issue to be tried at the stage where you're applying for an interim injunction. And Section 12.3 evinces an intention to depart from that general rule.
Yes, and in this sphere, American Cyanamid, indeed the Law Commission report, repeatedly regards threats as being subject to the American Cyanamid test, not subject to the higher 12.3 test imposed by the Human Rights Act. I'll come on to that very shortly because I've now finished my threat section and get to move on to the law. My lords, my lady, I will address my legal submissions on the law in the same order I set them out in my skeleton, and as I foreshadowed earlier, as I go through this I will be making the points, so when I get to the grounds it'll be very short and sweet at the end. And what I will deal with first is the threats regime, because the way that this appeal is set against my client is, of course, that Section 12 of the HRA is then a fetter in the threats regime. So it's important, we say, to consider the threats regime first, and then consider how, if at all, it derogates from that. It's also important to consider it that way around because, of course, the HRA predates the Law Commission report and also the Threats Act that was brought in 2017. Now, dealing first with the background to the threats regime, as I've already discussed, one can see the particularly pernicious evil that arises of threatening somebody's retailers or distributors. They don't want to get involved. They could just pull a product. They could limit their exposure to it. They may not pull it completely. They may stock a rival product. They justifiably may not want to get involved in litigation themselves. And of course, the law was most recently amended in 2017. And the Law Commission was looking into threats for 3 reasons. Just to summarise what they were. Firstly, it was the complexity of the law as it stood. Secondly, there were concerns about the incompatibility of the threats regime with pre-action conduct as required under the CPR. And thirdly, because of the serious harm that groundless threats can cause. And that's all set out in detail in our skeleton argument. But there are parts of the Law Commission's
Just before we dive into the detail, can you just give us a headline as to why you say the Law Commission reports are relevant, given that there is nothing in the legislation about interim injunctions at all?
The reason we say it is relevant is, well, firstly, it talks in numerous places about injunctions, both interim and final, and therefore, considering the Law Commission's work and report on this, I accept that the bit that my other friend took you to earlier, where it talks about the availability of injunctions, we say that should also be considered as including interim injunctions, because the prominence of the discussion of interim injunctions in the Law Commission report.
I'm sorry, I'm obviously not making myself clear. Let me try and clarify my question. So, the normal relevance of a Law Commission report is as follows. You have a piece of legislation which has been enacted following the Commission, and there is an issue before the court as to the interpretation of that legislation. And the Law Commission report is relied upon to identify the mischief to which the legislation was an answer, and
yes,
thereby to assist in the interpretation of that legislation. But which provision of the 2017 legislation do you say we need to interpret?
Well, we say it's relevant in 2 regards. One, that word injunction that was in 21C, I think off the top of my head.
But that's a final injunction.
Well, we say that should also be interpreted as including the availability of interim injunctions.
Okay, so can we just turn to that?
Yes, of course.
And have a look.
Or just let me just push away the core bundle up so I need that for a little bit. So tab 3.
So it's page 13, yes?
Yep.
So section 21C, I mean, this is unchanged from the previous legislation, but that's by the by. Proceedings in respect of an actual threat made brought against the person who made the threat for A, declaration threat is unjustified, B, injunction against continuance of the threat, C, damages. So the proposition I put to you is this is all final relief and you're disputing that.
Yes, we say that given the, as I will come to, the repeated references to the availability of interim injunctions, and furthermore, the importance and prominence of interim injunctions as considered by the Law Commission.
Sorry, I just want to focus on the legislation.
Yes.
I know you're very keen to get to the Law Commission, and I'm not going to stop you. Please be assured, I'm not stopping you from drawing attention to what the Law Commission had to say, but I want to understand the relevance of it before we get there. So, your first submission is that when we read in 20C1B an injunction, that is not restricted to final relief, it includes interim injunctions.
That is correct.
Right, okay, that I understand.
And then
But where is there in this legislation anything about the criteria to be applied when deciding whether or not to grant an interim injunction?
so that goes to the second reason that we say the Law Commission reports is relevant, which is that there is nothing in here that changed the position that the Law Commission regarded as being in place at that time.
So you're relying upon a legislative vacuum.
In a way,
Do I understand
yes.
you correctly?
Yes.
So
And
we are using the Law Commission report to interpret a legislative vacuum.
Yes, in the sense that it's an unusual submission, my lord, I accept that. But the point is this, that serious consideration was made of the threats regime. At no point did the Law Commission ever think that there needed to be threats addressed to the question of 12.3.
They might have been wrong.
They may have been wrong, yes.
We're not working out what the Law Commission's intention was. We're trying to work out what the Parliament's intention was when it
Quite.
comes to legislation.
I fully accept that, my lord. I fully accept that. And therefore, we say it would be, and that buttresses the first point I make, we say, and that injunction here has to be construed as including interim relief, because it would be unusual, to say the least, if the Law Commission had given such consideration to the importance and primacy of interim relief, but then didn't have anything addressing it, didn't have anything addressing the interplay of section 12.3, and that is why. So I guess the second reason is buttress on the first reason, which is the availability for an injunction in 21C1B must be construed as to include an interim injunction.
Okay, so where in the Law Commission do you want to
So
look?
first, if you could please, this is in the second horizontal tab 34. This is firstly the consultation paper. And if you could please go to page 618. And I just wanted to go to this first paragraph very quickly because this is the starting point to put the context of this. Where you can see in paragraph 1, it's talking about disputes relating to patents, other IP rights are widely used, expensive, complicated, and best avoided. A business can be severely disrupted until the issues at stake have finally been resolved. This gives threats of infringement proceedings their formidable force. When a threat is used appropriately, it provides important protection to the rights holders. When it is misused, however, it can do great damage. And that damage is then spelled out a little later, page 623. Paragraph 30, where it records that threats provisions aim to prevent a rights holder shutting down the network of supply without the risk and cost of proceedings to justify their claim. The fear of litigation costs and availability of alternative suppliers, including the rights holder, act as a powerful incentive for a retailer or distributor to abandon a product and stock another. This is as true today, if not more so, as it will have been in the 19th century. And then at the bottom of 31, it goes on to say that the proliferation of intellectual property rights has, in the Law Commission's view, increased the fear factor of threats. And of course, that harm is caused early on. Then, on the next page, 624, you can see that the Law Commission did have in its mind the CPR rules. It recognises that obligation is fraught with difficulty. So that was the background to the consultation paper. At no point during the Law Commission's consultation process was there any indication that there should be a particular difficulty or higher threshold applied, i.e. Section 12.3, or particular Article 10 issues. Indeed, on the contrary, it seems to be, we would say, assumed that standard American standard principles would apply. And can you therefore, still in that tab 34, please go to page 662. Where it talks about remedies for groundless threats at Para 252. It says remedies include an injunction, including an interim injunction against the continuance of threats. And then at 254, it says before making an interim injunction, the court must be satisfied that it is arguable that a groundless threat has been made. The principles, and then if you look at footnote 78, it says the principles upon which an interim injunction will be granted in Chapter 1. That then, if you go back to Chapter 1, page 648, sorry, 647, just so you can see where we are. Back in Chapter 1, remedies for infringement, Para 1.771. Some remedies for infringement are common to patents, trademarks, and design rights. They are, and then over in 648, an interim or final injunction to stop or prevent the repetition of infringing acts. And then it goes on to consider the language of the American...
Sorry, this is remedies for infringement, not remedies for threats.
Yes. But it's referring back in the interim injunction stage in 254 that I was talking about.
Well, that suggests, I mean, it's a little while since I've read this document, but that suggests there is no specific consideration of the criteria to be applied to interim injunctions to restrain threats.
Well, in the bit that if we go back to page 662, I'll come on to some other points in a second. That is referring, we say, to the American Xanamid test.
Well, this is what I'm questioning, because there is a cross-reference back to Chapter 1, and it may be that there is something that I'm missing, but what you've taken us to in Chapter 1 is not remedies for threats, it's remedies for infringement, which is quite different.
Yes, I accept that, my lord. It does...
So is there any discussion, I repeat my question,
yes,
of the criteria for interim injunctions specifically with regard to the threats?
Consultation does refer to the Quads for Kids case. I will find that reference for you, or one of my juniors will, because I haven't noted it down, but it does refer to the Quads for Kids case, which was an interim injunction granted in American Xanamid principles in relation to threats.
Is there a reference to VET Plus? Am I missing something?
I don't believe so, but I will double check.
And is there any reference in any of this material to Section 12 of the Human Rights Act?
There's no reference at all to Section 12 of the Human Rights Act.
So
Your point really is that this all proceeds on the assumption
Oh, yes.
that the unstated but implicit assumption that Section 12 doesn't apply in this context.
Yes.
How does that help us with the interpretation of what was enacted by Parliament?
As I said earlier, our position is that when the amendments were made to the threats regime in the 2017 Act, and that reference to injunction should be interpreted as the inclusion of interim injunctions as well, and there's no suggestion anywhere that the higher threshold under 12.3 is to apply in this context.
But nor is there any suggestion that it shouldn't.
I accept that. It does very much seem to.
Well, logically, if Section 12 on its natural interpretation does to this situation, it would have to be excluded expressly.
Yes.
And not by implication in a
Yes,
law
I
provision.
accept that, my lord.
So really to come back to whether Section 12 does apply, and the judge proceeded on the basis that it did.
Yes. Let me just check. So the reference I mentioned to quads for kids is on page 654. And that was a case that applied interim injunction.
But where does it refer to the interim injunction? I mean, it's discussing quads for kids because of the issue that was subsequently resolved by this court as to whether, in the notice and takedown context, there's a threat at all.
Yes, my lord. I accept that, and part of my submission is, and this is why it's a bit more tricky to make out, is that there was no discussion, which we say would be, is a particularly relevant factor here. There was no discussion of any higher threshold being applied under 12.3.
Yes, but sorry, with respect, that's not an answer to my question. The question I was asking you is, why is the Law Commission discussing quads for kids in this paragraph? And what I was putting to you was that if you look at the last sentence, the reason why it's being discussed is that it was held to be arguable that the right holder's submission of allegation under the Vero programme was a threat. That's why they're discussing it. And that was the issue that was resolved a couple of years ago, finally, after a long hiatus by this court, where we held that actually Mr. Justice Pumphrey was right. It was indeed a threat. But that's why they're talking about it. They're not talking here about the criteria on an interim injunction application, are they?
So, if you could please turn then to page 663.
Probably
to my
by
junior.
inference of the use of the word arguable, possibly. All lines up from the bottom of that paragraph. But that's the most we get out of it, I think.
Yeah.
So over the page at 663, 255, it says, this is in line with what we have been told by stakeholders. Interim injunctions are viewed as an important remedy against the harm a threat can do in snuffing out a commercial activity. Great commercial damage can be caused, especially in a seasonal or fatty market that may have run its course by the time the main issues have been decided. Then it refers to the quads for kids in that place. I did know it was in here somewhere. I'm grateful to my juniors for finding it.
Right, so that's a bit more pertinent.
Yes. It is also pointed out that many threats actions are taken no further once an interim injunction has been granted.
Okay. Anything else that's helpful in this document?
So, if you could now please turn to 672, page 672. And this is where actually it does, in a way, address this interplay, albeit not directly, with section 12.3. So at 672, you can see chapter now considering other forms of protection, such as malicious falsehood. And then over the page at 673, it says in paragraph 4.5 that a further drawback of malicious falsehood claims is the difficulty in obtaining an interim injunction to prevent threats of infringement proceedings being made or continued. For a person aggrieved by a threat, this is often the most desirable remedy, as an interim injunction can reduce or eliminate altogether the commercial damage done by a threat. The usual rules that the court apply when deciding whether to make an interim injunction do not apply in a malicious falsehood claim, due, of course, to the rule of Arnold and Perryman. And then it goes down to bottom 4.6. The background paper concludes that claims of malicious falsehood are not a satisfactory alternative to threats provisions.
And the main obstacle is proving malice, not falsity.
Yes.
Arnold and Perryman is very, very much higher hurdle for a claimant than section 12.
But then it goes on to consider defamation. In the
So
next.
can we just pause to note that this answers the question that was asked earlier?
Oh, yes, it does,
Because
yeah.
VET Plus is cited in the footnote. Of course, no mention of section 12.3.
No.
So you were going on to deal with defamation.
Yeah, so it then goes on to consider defamation and other avenues, but again, there's no suggestion in here that 12.3 applies. I appreciate it. I can't make the point anymore because it doesn't discuss it, unfortunately. It would have been quite useful for me if it
but
had.
I think Green and Associated have been decided by this time, which held that section 12 doesn't apply in defamation, and Arnold and Perryman continues to prevail.
Yeah.
So it's really the same point as malicious falsehood.
Yeah. And then just let me check one last reference. So if you please now turn to page 36. Tab 36, sorry. Tab 36, page 943. So this, what I took you to earlier was a consultation, now is the report. And on 944, you can see this was presented to Parliament. This is report number 360.
So this is the second report, not the first.
Yes.
So I
And
take
this-
it from that there's nothing in the first report, which is tab 35, that exists.
Not at present, no, I'm not going to go to anything there, my lord.
Right, thank you.
And this goes to the final point to make an answer to your question. The outset, if you go to page 999, where it says remedies, it cites section 70C.
Sorry, I missed.
Sorry,
It's your.
page 999
Thank you.
in tab 36.
Yeah.
Unchanged from the current law.
Yeah, and it says in 442, having cited the part of the statute that we just looked at, so it's 70C here, that was in the Act, this has obviously been put in different places in the respective Acts under patents and trademarks, etc. It says in 4.42, an injunction may be obtained as an interim or final remedy.
Right.
So again,
So what we get from this is that there was, in this respect, no intention to change the law.
yes.
And the law as it then stood included section 12.3 and it included VET plus.
It included VET plus, it also included quad for kids, which was an interim injunction granted
Right.
on American Standard
So
principle.
no change to the law.
Yes. But again, no change to the law in circumstances where the Law Commission regards interim injunctions as being important. They certainly didn't think they needed to change anything, because it certainly appears that they were operating under the assumption that interim remedies are very important and available, and not in any way changed by section 12.3.
They simply don't address section 12.
Yes.
So if their assumption is wrong as a matter of law, how does that help us?
I accept that it's entirely possible that all of the people who put into the consultation and the Law Commission may have missed this issue, but we could not see any discussion of the higher threshold being applied, and until this case there has been no suggestion that this higher threshold applies in threats, interim injunctions until now.
Yes, but it had been raised in the VET plus case, which was, as we've seen, discussed in the report.
And I will come on to VET plus shortly to explain why that is a different matter than the present case.
But
Indeed, VET.
the point I'm struggling with at the moment, and let me try one last time to see if I can understand your submission, is given that there's no consideration at all of section 12.3 anywhere in either the consultation paper, the first report or the second report, how can we draw any inferences from that?
Because there is consideration, albeit limited, of the importance of interim remedies and of the American Standard, because again, there's quads for kids is referenced and there's no discussion anywhere that the American Standard test isn't applicable.
So it's not just a legislative vacuum that you're relying upon, it's the failure of the Law Commission even to consider the issue that you rely upon.
I guess the way I'm putting it is, my lords, that up until this case, nobody has ever considered that 12.3 applied in these circumstances. And it's entirely possible, I accept, that we've all been labouring under misapprehension. But given the particularly pernicious nature as discussed, one would assume that if that higher threshold was to be engaged, that there would have been consideration of it, given the findings.
Well, I mean, I appreciate proving a negative is always hard, if not impossible.
I am struggling somewhat
But,
with it, yes.
but what's the evidence for the proposition that nobody considered that 12.3 applied in these circumstances? Why is it not equally possible that actually plenty of people considered that it did?
Because having been through all of the reports and all of the submissions, there isn't, we can see anywhere, any discussion of it at all. I appreciate that as proving a negative,
but the silence is surely neutral. People can be silent because they think there was no question of section 12.3 applying, or they can be silent because they think it's obvious that it applies.
I accept that as a matter of logic, the silence can cut either way, but I would say as a realistic proposition, that if 12.3 was believed to have been engaged and the higher threshold and consequences it has, particularly as I mentioned earlier in relation to patent threats, where you have to have questions of expert evidence, etc., that would have to be determined at an earlier stage, it would, we say, as a matter of realism, if not a matter of strict logic, be mentioned at somewhere at some point. So I appreciate that proving the negative is difficult, if not impossible. But there are so many. This is not a short set of documents.
Well, the negative you proved is that there's no mention of section 12. There's
Yes.
no reference to it anywhere.
Yes.
Or subject to contradiction.
And there is some mention of
I
American.
know from personal experience, and we can see it in AFSAR, that plenty of people thought that section 12 is just about the media. That's all it's about. And that may be an assumption that was made by everyone involved in this consultation. Nothing to do with us, we're commercial people. Now, the judge didn't take that line. You've got no respondents' notice, so it's not really open to us to reach that conclusion, even if we were minded to. And so it's difficult to see where the Law Commission is taking us, unless it said, if it could have said, obviously, this is so important, interim relief is absolutely crucial, and we've been persuaded by all the submissions that we've made that Section 12 shouldn't apply, because it would make an awful mess of this area of law, because it's impossible to prove who's going to win until you get the judgment. And we recommend that there should be a legislative intervention. None of that happened. So we're just left, as my lord says, with a vacuum.
I accept that, my lord. I did, however, take you to the point where they did discuss the importance of interim remedies to stakeholders.
That begs the question, doesn't it?
It does to a certain degree, yes, I accept that.
Yeah.
Is
My
that
lord,
a convenient moment?
That's probably a convenient moment to stop my battering and bruising and give me lunch.
We will try to intervene a little less when we resume at 2
My
p.m.
lord, fine.
All rise.